back to winning isn't easy. Let's talk about step 5 in the Social Security world and do a discussion of the intersection between step 5 and the ERISA any occupation definition of disability. Now, in the context of a Social Security case, if you can't perform your past relevant work, the analysis can move on to step 5, which is somewhat similar to the any occupation analysis in an ERISA case. Step 5 in the context of a Social Security case is that mythical test. Is there other work in the mythical, hypothetical, not real world national economy that you wouldn't want to do that does not pay a living wage in view of your age, education, skills, and your restrictions and limitations? And there are some significant differences here. Social Security does consider age, but generally an ERISA policy or plan does not consider age as a factor. Again, so you've got to go look at the context of your specific ERISA policy or plan. What's the definition in your policy or plan? Because that's the starting point for the analysis. The analysis, I will tell you, is much the same from my perspective as an ERISA and Social Security disability attorney. I find that there are similar mistakes that are made by Social Security vocational evaluators and by Social Security reviewing or consulting physicians or the opinions of their vocational evaluators that can lead judges to make mistakes. And similarly, the same thing happens in the context of an ERISA disability claim. There is one big difference that you need to understand. At step 5, there is something called the medical vocational grids, and there is a significant difference in whether you're entitled to benefits, in part based on age. If you're over 50, then the grids become applicable. And there are two ways to meet step 5. There's to grid out, and if you grid out, that's great, your benefits are awarded. But if you don't grid out, then they'll determine your entitlement to benefits based on that mythical hypothetical test. The grids are a chart that are in part based on sedentary, light, and medium exertional levels that are matched to your education and age. So literally, it's a grid. You can look at the top of, for example, the grid for sedentary work, and you can see what the education level has to be, what the age range is, whether there's transferable skills. And you can look across this grid to see whether or not you are disabled or not disabled. It's a very rote analysis, not quite so in the context of a ERISA claim. But one of the factors in applying the grids is exertional levels and transferable skills. Now, non-exertional impairments can really change the exertional level and can impact transferable skills. And I'll be talking about this in later videos. So if you grid out, that's great. If you don't grid out, then we are now in that mythical, hypothetical, not real world analysis. So what are the 3 types of job skills that Social Security is trying to determine to see whether or not there are transferable skills from past work to other work? This transferable skills analysis is much like what's done in the context of an ERISA case, but I think there are going to be some significant changes. Why? Well, as I've said, Social Security is changing their analysis of past relevant work from the 15 years before somebody became disabled to the 5 years before they became disabled. In the context of an ERISA case, the carrier or plan is looking at your entire occupational history to determine whether or not there are transferable skills from past work to other work, as those terms are defined in the context of your policy or plan. So there are 3 types of job skills. There's skilled, semi-skilled, and unskilled. Pretty self-explanatory, but Social Security is going to have a vocational expert at a Social Security hearing to determine if the hypothetical individual has skills that would transfer to other work. And that grid chart is based on exertional levels that match your age, education, and skills. and that will direct a finding of disabled or not disabled. Now, grids are used at the initial claim stage and at the recon stage and at the hearing stage. So it is clearly possible for Disability Determination Services, DDS, who reviews claims at the first two levels, to apply the grids. If the claim gets denied and we end up in front of a judge and my client's over 50, I'm always trying to argue that my client grids out. Now, let me give you an example. Let's say you have a back condition that limits you from standing and lifting more than 10 pounds. That's going to limit you to sedentary work. If your skills from your past work doesn't transfer because those skills were performed at a higher, or those tasks that were performed at a higher level that would result in transferable skills, then you're not going to be able to have transferable skills to sedentary work and you'll be found disabled. So there is this analysis. I don't, what will happen, of course, in the context of an ERISA case is if you win and you win because you've gridded out, the carrier is going to say, well, too bad, so sad. We don't have to take it into consideration because age was a factor and age is not a factor in our definition of disability. So they'll cut that and slice that Social Security decision any way they want. What's the other way to win at step 5? Now, if you're under 50 or you don't grid out, the Social Security Administration analyzes whether there's other work that you can perform based on your education, transferable skills, and functional, physical, and psychiatric restrictions, limitations. If we have a hearing, there's going to be a vocational expert who is going to be asked questions by the ALJ in the form of a hypothetical to determine whether or not you meet step 4 and 5. And I will tell you that these hypotheticals can make or break your claim. In fact, that's one of the reasons why you should have an experienced Social Security disability attorney representing you to challenge the hypothetical the judge gives and to challenge the vocational evaluator's testimony. I find that many times the judge does not ask the right questions about the residual functional capacity, and as a result, the Social Security vocational evaluator will identify other work in the national economy that the claimant is allegedly capable of performing, which exists in significant numbers. And there's a lot of buzzwords there, but those are buzzwords that we Social Security attorneys want to attack if we get an unfavorable vocational opinion. Now, unlike an ERISA case, the amount of money that you can earn at any of these hypothetical jobs is not a factor in determining your entitlement to Social Security benefits. In fact, many times at the sedentary level, vocational evaluators will say things like, your client could work in a laundromat folding towels. Your client could be a surveillance system monitor. Your client could be an addresser. Your client could sort nuts and bolts or peanuts and pecans. Your client could sit in a restaurant and take that beautiful silverware and wrap it in that nice napkin. Nobody wants to do those jobs. They don't pay a living wage. They don't really necessarily exist, I think, in significant numbers. But nonetheless, I hear those jobs all the time. That is a completely different standard of disability than it is in the context of an ERISA claim. So the game at step 5 for Social Security purposes is to conclude that you can do at least a sedentary job and you have transferable skills and that the jobs exist in significant numbers. And that's pretty darn close to what the game is in the context of an ERISA claim. So they want to argue that you can do sedentary or light work, you have transferable skills, there are other occupations that you could do at a wage such that no ERISA disability benefits are payable. So you can see there's this intersection of sorts between Social Security and ERISA disability claims. I hope that you have enjoyed this week's episode of Winning Isn't Easy. Please like this episode, like our page, leave a review, share it with your family or friends. Please subscribe to this podcast. That way you'll be notified every time a new episode drops. Tune in next week for another insightful episode of Winning Isn't Easy. Thanks.